let's get stuck in, and we need to start talking about cost agreements and disclosure. I suspect this section will be broken up into two different videos. We'll focus on disclosure in this one, and I'll move on to the agreements themselves in the next video. So why are we going to spend so much time talking about costs? At the end of the day, lawyers' costs are really a live issue in the community. They tend to attract the attention of the reform bodies over and over again, and in part that's because there are just so many complaints that have been associated with costs. At the end of the day, by the time we get to a client making a complaint, usually the relationship has broken down irrevocably, but we really end up with a lot of the disputes focused on costs, in part because it is very difficult, particularly for non-commercial clients, to understand why the costs are as high as they are, in part because many lawyers are not very good at talking about money. They're not very good at the disclosure piece. So in part it can just be because the client is unsatisfied with the outcome and the bill becomes the final straw. There are a lot of different reasons, but because there have been so much concern about lawyers' costs over the last 30 years or so, and because lawyers effectively have a virtual monopoly on legal services, and we keep coming up with that moral hazard concept or potential for conflict that I've spoken about a number of times, where there's an information asymmetry. The client has a problem, there is a legal aspect to it, but the client doesn't understand the law, doesn't understand the complexity, and is really reliant on the lawyer to tell them what kind of service that they need. Ultimately, this has driven the law, legislation in particular, to impose a range of different safeguards on the way that lawyers charge costs. They include things like the extensive cost disclosure requirements that we're about to speak about, the requirement for costs agreement to be in writing, the prospect that cost agreements will be set aside in a range of different circumstances, rules that relate to the way that bills of costs can be reviewed by an independent adjudicator, and ultimately disciplinary sanctions for lawyers who charge excessive fees. So in this topic, we're going to talk about the what, when and how of making disclosures in relation to clients, both new and existing. And then we're also going to try and identify the specific information that needs to be provided to the client in the context of settlement of litigious matters in particular. Now, I won't go into it, but it is worth noting that there is kind of this historical information about costs, and that prior to the 1980s, pretty much every lawyer charged by reference to a court scale. But since the 1980s and the introduction of what was initially proposed as kind of an efficiency methodology, most lawyers have begun recording their time and billing based on the time that it takes them to do things. Now, the root cause of a lot of customer dissatisfaction has been this kind of bill shock, to use the word that we often talk about in the context of our telephone bills back in the day. Both approaches, both the scale billing and time-based billing, are used, but time-based billing is by far the most popular. But again, because of that information asymmetry, it can be very difficult for the user of legal services to understand whether the time that was spent by the lawyer was spent effectively and efficiently or not. Now, we have a duty of care as lawyers to approach legal matters as efficiently as possible, and much of the conversation that we had earlier on in this semester as we were looking at different kinds of technologies We're about finding ways that lawyers can use technologies to be more effective and be more efficient in the way that they deliver legal services. But here now we're going to talk about it more in the sense of, are we charging the right amount, and is that the right thing to do? I've got a QR code on the slide. That'll lead you to the Legal Practice Board and Commissioners website, where they talk about the extent to which complaints and auditing issues are showing them, the data that they get out of that is that many lawyers the way that they perform their services, charged at an hourly rate, leads to dissatisfaction with billing practice. That particular page I think is particularly interesting because it's showing how the profession itself is really at a turning point and rethinking the ways in which we charge for our services. And while it's not particularly on point for any exam that you're going to get, well, actually, as I say that out loud, I do wonder whether there is real value in thinking about the approach and the business model that we take to timing, how that could be affected by technology, and how technologies are used to make practice more effective and more efficient should be reflected in the way that lawyers charge. And further, if lawyers are going to enter into contractual arrangements with their clients that say they charge by the hour, the extent to which they use technologies to minimize that time, how do they charge then for the investment that they've made in setting up that technology or training that AI? I think that's a really interesting question. Might be a reflective piece, just might be worth thinking about. So let's get stuck into the law rather than reflection to start off with. The relevant part of the uniform law here is part 4.3, and that sets out some clear objectives for the cost regime. In particular, the objectives include ensuring that clients of law practices are able to make informed choices about their legal options and the costs associated with pursuing those options, as well as to provide law practices with the obligation that they not charge more than is fair and reasonable for legal costs. One of the things that really comes out of part 4.3 of the uniform law is the importance of communication. And in all of the reviews of the regulations, the legislature has referred to the importance of communicating fully and fairly what the costs will be is part of the expression of the relationship of care between the lawyer and their client. So part of the obligation of the lawyer, particularly expressed through the relationship of care approach to legal ethics, is one that requires transparency around pricing. So a law practice must not charge, well, in fact, the way the wording works, it's actually kind of a double negative. A law practice must charge costs that are no more than fair and reasonable in the circumstances of a case. And in particular, the costs need to be proportionally and reasonably incurred so that they are proportionate and reasonable in amount. They need to be set out in the retainer, and the uniform law provides some guidance about that idea of proportionality and reasonableness. So let's get some definitions right before we get much further on. So the term legal costs as defined in the law means, and take a look at section 6 to get there, the costs that are charged by or that a person becomes liable to pay to a law practice for the provision of legal services, number one, so the professional services, or charges that are disbursements or out of pockets. Now, these charges, legal costs, might be paid by the client or might be paid by a third-party payer in respect of those services provided by the law practice to another person. So a third-party payer in this context could be somebody who has taken on the obligation to pay the fees or pay the legal costs. For example, a litigation insurer. So when we talk about out-of-pocket expenses or disbursements, we're talking about the expenses that are specifically incurred on behalf of a client. So they might be things like barrister's fees, the cost of obtaining reports, say from doctors. They could be court filing fees. They could be the cost of undertaking searches. So the fees that might be paid to ASIC, the Australian Securities Investments Commission, for example, to obtain a company report. They may include things like stamp duty or other taxes. And they could include the cost of getting documents printed or couriers, a range of different things. What's really the focus of our discussion will be that other component of legal costs, the professional fees that lawyers charge for the legal services that they provide. So this is what we're mainly concerned with in this particular area. And again, the definition, you'll find it in Section 6 of the Uniform Law. So there's lots of different ways of charging professional fees, and Parker and Evans provide some really good descriptions how each of these work. So of course there's the per item of service. We could talk about hourly billing. I've mentioned this a number of times. There is nothing to stop a lawyer from charging a fixed fee or a flat amount for a service. It's actually fairly rare now for law firms to be involved in actual divorces. They're pretty simple and easy to do online when they're not contested. But in relation to the property settlement between a married couple or a soon-to-be divorced couple or a recently divorced couple, it's quite usual for firms to charge a fixed fee for that piece of work, for example. Conveyancing and transfers of land, again, quite often a fixed fee. Wills, similarly, a fixed fee is quite common. We can also talk about conditional costs arrangements, and we'll talk about them in some detail in a minute. One of the ways that we might see law firms in other countries charging is on a commission or a contingency basis. So a percentage, say, of the value of the claim when it's paid, or the price of the deal. This kind of commission or this kind of contingency is essentially banned in Australia at the moment, and in relation to those states who have the Uniform Law, Section 183 will help you there, and the reasons for that are essentially ethical and about maintaining that independence. So the different ways that we charge fees are a live issue for the profession at the moment. Michael Kirby, way back in the mid-90s, actually asked the question in a paper whether time costing was a reward for the slow-witted. There is no incentive, it can be argued, to do something quickly and efficiently if you are charging for the time that it takes to do the thing. Now, many other lawyers will argue that because we have ethical duties that require us to work in the most effective and efficient way possible, then that's not the case. But it does rely on the customer effectively to trust us that we're not wasting our time when we are working for them, when we use time costing. The chart that's on the screen, it's taken from that page of the Legal Practice Board website, provides a really neat little pricing model summary table. Now, hourly rates are by far the most effective, and I think it's a really nice way of sort of showing the pros and cons of each. We see, sorry, I think I just said that hourly rates are the most effective. I think what I meant to say, if I did say that, is that they're the most common. We do see more and more agreed price on the less complex type transaction end, where there is more security or more security from the lawyer's point of view of how long it will take to do something. In part, I think that reflects the way that lawyers or most businesses actually work out their costing, because even though most lawyers are salaried, the time that the lawyer takes is kind of the biggest input into the equation. So when they have data that reliably indicates how long it is that it's going to take them to do something, they basically use a version of hourly rates to calculate with a view to getting an agreed price. Now, this isn't always the case, but I think that's why we see at the less complex end, we're seeing more agreed pricing. Something that's happening a little bit more often, but is still pretty new and is really a new law model, is the subscription model. So there are some new law firms where effectively what is happening, small businesses and others are essentially committing to a minimum fee each month or each year for which they receive legal services, a bit the same as you might subscribe to a gym. The gym doesn't know at the time that they take your subscription fee how often you're going to visit, and they basically make a bet that at any given time there won't be too many of you there that can't provide the services, I guess. So we're seeing and we would call this new law, a little bit more happening in that space, and it's definitely of interest to the Legal Practice Board and Commissioner in Victoria. But there are all sorts of other methods that are coming out, and it really kind of asks. It comes back to, well, what are these new methods? What problem are they trying to solve? There is a question about whether bill padding is happening a lot, and many are concerned that there are, it's the stuff of TV shows and novels, I guess, that people are putting more time down on their timesheets than they actually spent on something, and which, is unethical. It's actually a form of theft when you think about it. My experience, to be frank, is actually the opposite. If people are dishonest on their timesheet, it's more likely that they don't record as much time as they probably should have. And in part, that's usually junior lawyers in law firms who are concerned that the people that they work for will think that they are, as Michael Kirby put it, dim-witted. They'll think that they're taking too long to get something done. It's a real catch-22, because the more people cheat on their timesheets by saying that they didn't spend very much time on doing something, that in turn fuels a misunderstanding higher up in a law firm as to how long it takes people to do things, and then it's one of the reasons why we see so many junior lawyers in the profession being overloaded with work. And it's a really difficult, really human problem to solve. So I would, rather than talk about it as bill padding, I would think bill padding and bill shaving are both issues. Jen Spiegelman, former Chief Justice of the Supreme Court of New South Wales, has been railing against time billing for some time. He basically uses the language in a February 2004 New South Wales Law Society dinner speech. It is difficult to justify a system in which inefficiency is rewarded by higher remuneration. And I think that's certainly something that we need to think about. But we also need to think about the way that the targets work. Most law firms will have billing targets of between 6 and 8 hours of a day. And it can take between 9 and 12 hours to actually produce 6 to 8 hours of billable work. And they're long days, it's hard work. And there's been a lot written in the Law Society Journal and other places about the impact of time billing on the profession. have a look at Parker and Evans. I've taken a screenshot there of the process that they talk about in the chapter that you've been asked to read there. They've got a great analysis of the way that costing can be approached under various different ethical lenses, and that's definitely worth thinking about. So in the next video, I'll walk you through section 174, and we'll talk about the requirements for disclosure. But I just wanted to finish off this little bit here. It is really important for you to continue to think about the why, and think about the way that the ethical rules, so in particular the Australian Solicitor Conduct Rules, which we will keep coming back to over and over again, and the Uniform Law, think about why they are the way they are, the way that they have evolved, and really the mischief that they are there to prevent, or the problem that they are there to solve. And when you think about that through the technology lens, I think that you'll end up with some really interesting food for thought. Again, that will really help you as you get particularly towards exam stage, but also with the second assignment, as you can reflect on the ways that these rules work in practice, which will be really useful for you from the assessment tasks, and actually more importantly, so that you can be great lawyers, great ethical lawyers moving forward. I'll see you in the next video.